If you would proceed, ma'am.
My name is Linda Simon. My divorce from a successful personal injury attorney who was represented by the president of the Bar Foundation speaks loudly of the corruption in the courts and the boys' club that protect each other. Multiple attorneys, fraud, collusion by the court that turned a blind eye and helped perpetuate the fraud. When I was charged by the opposition and the court as being the uncooperative culprit, just after something none of my attorneys could find and didn't exist. But the truth is, it was a shell game, a financial hara-kiri to exhaust me and my attorneys, who failed me miserably. The original trial judge was mysteriously replaced by Judge Stephen Aldridge without prior notice to me. At the initial case planning meeting, Judge Aldridge admitted on the record that he worked with my ex-husband's attorney, David Forrell, for many years. I discovered after the divorce that Judge Aldridge actually officiated at the wedding of David Forrell at a lavish affair at his home just 2 years prior to Judge Aldridge suddenly appearing as my trial judge. I brought to Judge Aldridge numerous discrepancies and evidences of fraud and crimes being committed by my ex-husband, but the judge would do nothing. My ex's tax statements given to the court said he made only $19,000 a year, but my ex verbally claimed to the judge that he made $50,000 a year. In actuality, both numbers were a gross misrepresentation, and I have the proof. Judge Aldridge refused to enforce his own orders. My ex was ordered to attend a discovery conference and ordered to produce contracts on a law firm he purchased that was not disclosed to the court, but brought out to the court by me. When my ex ignored the orders and it was brought to the attention of Judge Aldridge on the record, he wouldn't address it and he did nothing about it. At one pretrial conference, while I was attempting to raise the issues, he just up and walked out of the courtroom, not to return. Despite the lack of discovery, he warned me not to file a motion to compel. The trial was a total scam. I was badgered to settle for their offers of child support and division of the assets. On the stand, I spoke of the malpractice, the neglect, the motion churning, the fraud, and pled to the judge to let my witness take the stand. But he said, I don't have to. I was awarded $5,000 in attorney's fees payable in 14 years. When the proposed stipulated agreement said I agreed to income, I ordered the transcripts in an attempt to get the official record. To my shock, the transcripts were altered and paragraphs of my testimony removed. I immediately contacted the court reporter and confronted her with the missing testimony and asked her for an audio, and she told me one didn't exist. I've spent over $50,000 in attorney's fees, and I've made a complete and comprehensive record of the case and what I've told you today and can provide that.
Thank you, Ms. Simon. I appreciate it. Representative Simon.
Sorry, thank you. No relation that I'm aware of.
No.
I wanted to ask you, you said something at the outset, too, which interests me. You said that you were misserved, you felt, by your own lawyers as well.
Yes.
Do you believe, and you said at the beginning that your ex-husband was prominent in the legal community.
Very.
Could you tell us a little bit more? I'm interested in what you perceived as the failure of your own lawyers. What was the failure, and to what do you attribute the failure, if anything?
Well, I largely attribute the failure to the boys' club that exists, the influence of my ex's attorney, who was president of the Bar Foundation. All of my attorneys told me that he was committing fraud. Statements like, I'm going to take a law firm down, I don't know how this has happened, if the divorce doesn't work out for you, find a good malpractice attorney. Discovery failed to be produced. There were no exchanges of discovery. And this went on for 2.5 years. Literally, it was a shuffling. You know, one of those things where you go, now guess which one it's under. Oh, look over there. Now guess which one it's under. No discovery was produced. We couldn't see profit and loss statements. He said he didn't do it. Couldn't see his billing statements. He said he just called his clients every month to tell them what they owed. It just went on and on and on. Multiple attorneys, no one filed a motion to compel.
Yeah, please, go ahead.
Mr. Chair. So what I understand you saying is the other side didn't produce information that you had requested.
Yes.
None of the attorneys that you had did what is known as a motion to compel. They usually have a set period of time when you ask the other side for something, they're supposed to produce it.
Correct.
If they don't, then you can file, your side can file something called a motion to compel that the court should hear. And I'm trying to piece it together. You're saying that none of your attorneys throughout this ever filed such a motion on your behalf. Is that right?
That's correct.
Any other questions from members?
If I might, then, did you file any complaints against your attorneys?
Like I said, I have a comprehensive record. I went to school for court reporting. I've been a legal secretary, and I kept every document, made notes throughout the entire thing, and I have an approximate, I call it a complaint. It's about 150 pages, including exhibits. But frankly, I have no trust in the Board on Judicial Standards or the Board of Professional Responsibility.
So, if I might, then you did not file.
I have not.
I'm sorry, you said you did not file a...
I have not.
Okay. Any other questions?
Ms. Simon, you said the judge walked out.
Yeah,
When did he come back?
he did not.
He just unannounced got up and walked out, and
Yeah,
so you sat and waited.
right.
And how long did you wait? And
Till I realized he was not coming back.
so did the court just adjourn for the day at that point?
Yes. This is a hearing that is on the record.
And you have this in a written statement, ma'am?
Yes, I do.
Okay. And if you could leave that for us, we will.
The complaint that I'm talking about, the rather large complaint, I didn't bring it with me today, but I'm happy to provide it.
Okay. Thank you. Thank you, Ms. Simon. Thank you for your testimony. Don Mashak.
Don isn't here. I'm not going to speculate, but he's been beaten up, and so I don't know if this is. He's not
Physically or mentally?
Well, both. Physically, yeah, he's been beat up. I don't know where he is, but I would like if we can have 3 minutes with John Dean, and he's ran for judge also. Just 3 minutes.
Certainly.
Thank you. I'll be as brief as I can. My name is John Dean. I've been a lawyer for 21 years. I practice in Anoka. I was a judicial candidate for district court in the 10th Judicial District this past election, and I garnered 153,000 votes in that district, and my opponent gathered 170,000. And I did indicate that I'm currently an elected official now. I'm a council member for the city of Ramsey, not the county of Ramsey. I've been serving as a council member for 2 years. But I was, I have 2 instances. I've been practicing for 21 years, and I echo Mr. Wurzel's comments. There's very much you're wronged as a lawyer. It's very difficult to do anything about it because you're as a lawyer, you're appearing in front of those judges on a day-to-day basis, and it certainly would be a disservice to your clients in the future if you were ever to call a judge to the mat, so to speak. So you've got to be careful about what you're going to do, what you're going to say, how forceful you're going to be. I remember one time, approximately 5 years ago, it might have been a little longer than that, I walked into Anoka District Court and was said, "Good morning, Judge." And the court stopped. It was a trial. The court stopped, and for 5 minutes, the judge questioned me on the rules of general practice, chewed me out up and down in front of my client about calling him judge instead of your honor. There's a rule that we have to, as lawyers, address the judges as your honor instead of judge. And I was very humiliated. And then he asked me if he, because he knew one of the parties, whether I would be comfortable having him preside over the trial. I whispered to my client and I said, "Not a chance." In another instance, I was defending a woman that was accused of attempting to murder her husband. I do a fair amount of criminal defense work. And I was given evidence, and within a week there was a contested hearing on a number of constitutional issues. I called the judge. His clerk indicated that I just received the evidence and that our contested hearing should be delayed, and asked the judge, since the time frame was so narrow, that if we could, that if I should have the motion for the continuance heard before the actual hearing. I was advised through his clerk to have it at the time of the hearing. I went to the hearing, and the judge required me to pay. He granted the continuance, but required me to pay for all the detectives that had showed up at the hearing. And I thought that was highly improper, but nevertheless I didn't say anything, of course, because I appear in front of them on a regular basis. But I wanted to now move to the part of the solution. When I was on the campaign, and I actively campaigned, garnering, like I said, over 47% of the vote in the 10th, a number of people that I would speak with indicated that they had voted early. And I said, "Well, tell me a little," you're talking to one of the candidates, "tell me a little bit about what went into your decision making on how you determined who was the proper choice." And I said, "Well, I'm embarrassed to say, but that incumbent designation that's on the ballot for only judges, I just voted for the incumbent because I didn't know anything about anybody." And I think, in my own view, if you have a bad judge, but you don't have an ability to have a fair election to eliminate that judge, through an elimination and get the ballot fair, you're going to perpetuate the problem where judges that are treating people poorly or have misconduct in any capacity, there will be a chilling effect, and no one will run against those particular candidates. I think you're well aware of that particular problem, and it hasn't been corrected, and I think it needs to be corrected before we start jumping into other types of reforms. I think that's a basic reform, that we can make these elections fair, and that's certainly my push and encouragement to the representatives and senators, is to get those elections fair and square first, where I can run head-to-head with somebody and not have to worry about what the percentage point separates us because he is the sitting incumbent.
Right.
As you know, you also went through an election at one point where you challenged an incumbent, and those designations were not on your ballot.
Right.
And I would encourage you to look at making that change. I think that will put us a step forward in this process.
Yeah.
Thank you.
Thank you. Thank you
Any
for your
questions?
testimony. Questions? Okay. Thank you so much. I appreciate it. And last one is Gail Lemaster. And we're trying to hold these to about 3 minutes, and then we're going to go right into solutions.
My name is Gail Lemaster, and thank you for coming and for allowing me to speak with you. I am currently in a very hostile divorce and custody battle in Dakota County. And The judge there has been responsible for a number of things that are not exactly something that is a good pedigree mark for the judicial system. The case is close to 3 years old now. It has not gone to trial yet, but it has already cost me, I believe, about $200,000 cost to me. And the finances are still rolling. There's a sworn affidavit that my husband sexually molested my niece. The judge refuses to consider this. A court-appointed PhD forensic psychologist evaluator found that my husband's a danger to our 14-year-old son, has documented in her report that she has watched him deteriorate under a 50-50 custody split with my husband, and the judge has not done anything. He has done nothing to protect my son or to even acknowledge the report. Our 17-year-old daughter, who professionals believe has appeared to be violated and sexually molested by my husband, will not have anything to do with her father, yet the judge, the parenting coordinator, tried to force her to spend unsupervised 50-50 time split with him. Our daughter became suicidal. She said to me, "Mom, I don't want Christian there going by himself. That's our son." She said, "But I can't go back anymore, not even for Christian." There's something wrong when a daughter says that about her father. The judge has not ordered my husband to maintain payments for the treatment of my cancer, nor has he ordered a financial allotment for my cancer treatments, even though that my husband has the purse strings for all of our money, and the judge knows and is on record documenting that he knows I'm fighting cancer. A judge ruled in a recent case that my husband committed fraud, was untruthful, and ruined the family, yet my judge is letting him do the same in my case and is protecting him, telling me, "You need to take care of him, that's where your money's coming from." The judge has repeatedly belittled me, shouted at me, and threatened me in open court. This judge stood up and raged at me. He turned purple, screaming at me across the bench for doing exactly what that man told me to do, and I have a tape recording of what he told me to do on a phone conversation. And he has treated me like that in court on many more than one occasion. He's done this with others, and there's even a newspaper article in the Star Tribune where it says Dakota County judge publicly scolded for disparaging remarks to a defendant in his courtroom. And the reporter noted that it had happened with my judge a number of times before that. So I am definitely not the only one that this is happening to. The same forensic PhD psychologist that was appointed by the judge found that my husband was a sociopath in her report. The judge did not file that report into the open case record. Instead, he appears to have ordered a new second evaluation at my husband's request. The first evaluation took almost 2.5 years because my husband, despite court orders for him to keep that woman paid so the report could come out, sat on it, refused to pay it. The judge did nothing. The judge actually said at one point in open court to me, he said to everyone, he testified in open court and said, "We all know there's no custody issue here, but since Mrs. LeMaster continues to insist on making it a custody issue and cause more time and cost to this court, I suppose we're going to have to allow this evaluation to come out." Now, how did the judge know that my husband was a sociopath? He has no documentation. He is not a psychologist. He stood there and testified, protecting my husband, belittling me. This is not the way that the judiciary branch is supposed to treat the people that come before them.
If you could wrap up, Ms. LeMaster, I appreciate it. And if you do have a written statement, we will definitely take that.
The judge has secreted information. He has allowed my husband to write non-sufficient fund checks. He not only allowed him to write them, he didn't uphold his own court orders. He also forced me to turn over the checks to my husband. He took away my ability to prosecute. He was in covenant collusion with my husband in doing that. The judge court ordered me to sign an IRS joint return. It's illegal to do that. He court ordered me to do it. He court ordered me to turn over my guns to my husband. It's illegal for him to do that. When he told me just to turn over the ones on the court order, and I did what he said, the judge then wrote an order saying he was throwing me in Dakota County Jail for 10 days for not turning over all the guns. My husband had no proof. I didn't even have one of the guns. I'd never even seen it, but he has an open court order still. There are numerous things. He's done judging on personal bias. He stood in his courtroom and said, gee, my dad died when I was 10. I'm going to say the kid can do that. You know, what I would give to have been able to do that with my son. My son is not this man. The judge is not supposed to take his personal experience or loss of a father and make determinations in a courtroom.
Ms. Lemasters, have you at any time put this before the Board of Judicial Standards? These allegations, have you written them up and then put them before the Board of Judicial
I've called the Board of Judicial Standards. I'm not getting any responses. And I'll tell you quite frankly, I'm afraid of this judge. I'm still in the custody. This judge is holding the reins to where my children go.
Yeah. My
husband has given money. I've seen him give a check for $10,000 to a minister that was going to tell him adultery was wrong. My attorneys are withdrawing like flies. I can appreciate attorneys getting leaned on. I know it's happening. There are so many things that have happened just in this case.
Ms. Lemasters, I'm going to have to cut you off. But at this point, if you have the allegations, if you could maybe put them down, we'll get together later and then talk about putting those before the Board of Judicial Standards. If there is conduct that is, in adverse to the bench, then those are things that need to go before the board, and that's what we'll talk about now. As we move into the solutions portion of this phase, and I know that Representative Simon has to leave here shortly. And did you want to go ahead? Yes, please.
Members, thanks. Representative Severson and others, and to all of you. I'm sorry I have to go in a few minutes, but I wanted to just chime in here on at least my ideas for solutions because I'm very interested in what you all have to say. A number of you in this room are my constituents, and we've talked extensively about this. So I just want to throw out a few ideas, and I'm sure there will be a robust discussion here. I'm just going to have to miss it, and I hope we have, or if we have future meetings, if we can flesh that out some more. It seems to me, stating the obvious here, we all have to be careful to distinguish between judges and the judiciary. They're not the same thing. There are some bad judges out there, but I think we have to be very careful not to paint the entire judiciary with that brush. And I'm not hearing that so far. I just think we all have to remind ourselves of that. That said, there is a black robe disease out there, no question about it, where some judges get it in their heads that they're, beyond reproach, and that's not the case. And there have to be meaningful avenues, if there aren't already, to make sure that they're held to account for some of the behavior that we're hearing described here. The problem, which I'm sure all of you have encountered, and I know we in the legislature have encountered over the years, is the doctrine of separation of powers, which is that the put it in regular terms, it's that we're not supposed to fiddle around in each other's affairs. And the further problem is that the entity that decides whether there's a separation of powers problem is the judiciary when they rule on whether or not the legislature has the right to, tamper with court rules and so forth. So that's going to be a natural difficulty in getting at some of this because courts may rule that it's not a legislative prerogative to get involved in these areas. So I think we have to adjust our expectations that way. That's not to say we should all just stand back and accept some of what you're describing. I'm just saying that's going to be a hurdle that we have to get over. Let me tell you about a couple of specific reforms that I think are a good idea, and I think you're going to hear from some prominent people here who have been very involved in this as well. One simple thing that we can do in terms of the appearance of impropriety is to do some campaign finance reform. All of us who run for office in Minnesota, as far as I'm aware, except for judges, have some sort of limitation placed upon them upon how much campaign money and from what sources they can accept that money. All of us who run for election in the Minnesota House here, any individual contributor can only give us $100 in the non-election year and $500 in the election year, and even then, there's a limitation on what overall we can accept from so-called large contributors. That's the same for county commissioner, governor, U.S. senator, almost every other office, I think every other office in the state, except for judges. Technically, and this hasn't happened as far as I know, thank goodness. But technically, if someone had the money to give and wanted to give a candidate for judge $1 million or $10 million, they could do that right now. There is no limitation whatsoever. And so I several years ago, I think back in 2006, I had some legislation just to have some cap in there. I didn't much care what it was, so I said, let's just set it at the highest level, which would be what the governor, candidate for governor, can receive. And I got to tell you, there was initial resistance from the judiciary that didn't want that in law and out. Now, I have to give them credit. They turned around and they reversed that position, and they've come to embrace it. As a matter of fact, the Supreme Court last October imposed by judicial rule the same limitation. In other words, the same as the governor. I'm not so sure that that will necessarily stick. I still think we probably need a statute in place and not just a court rule, but at least they've come around, and I give them credit for that. But one of the things that I think a lot of you have seen is the initial reflex reaction sometimes, not all the time, sometimes, by the courts has been to resist some of the reform proposals. And I think that reflex is an unhealthy reflex. And this is an example of that. An eminently reasonable, requirement to say you ought to have some limit. I didn't really care what it was. And you saw that initial reflexive reaction, and they killed the bill the first year. They didn't just politely say no. They actively went and got to the committee chair and said, kill this bill, and it was killed. Again, I want to give credit where credit is due. That was then. This is now. They've since come around. So I want to be very clear. They now see the wisdom in that position. And that's a good thing. But the other thing, and I know we're going to have some vigorous and heated debate on this, and there are many people in this room of good faith who disagree with me on this point, but one of the things that I want to see us move towards is a retention election system for judges. And I know Mr. Wursel and others feel strongly the opposite way, but let me tell you where I'm coming from on that. Right now, as you heard from Mr. Dean, the elections that we have right now are in many senses, not all, but in many senses not a fair fight. And what you have right now is a situation where 93% of the judges up for election skate without any sort of competition. It's the rare person, like Mr. Wursel, like Mr. Dean, who takes the time, raises the money, and goes and actually contests these elections. So right now, it is only even possible, based on the last couple cycles, for 7% of judges to lose their jobs. Only possible. Now, when we run for election, that's different. There's virtually 100% of us could conceivably lose our jobs because we draw an opponent. And so it's very difficult, and because of some of the impediments that Mr. Dean mentioned, it's just not practical to expect that anywhere near a majority of judges will even have an opponent. So they know as of July in the election year that they're not going to have an opponent. The advantage of a retention system, which Missouri and several other states have pioneered, is that you're voting yes or no on Judge X. So there was 100% of judges who were up that year who could, conceivably, if the no's outnumber the yeses, lose their job. And I think you would see, as you've seen in other states, a lot more accountability where that happens. And so I am now, for the second year in a row, sponsoring that legislation, which is the result of the QUI Commission you might have heard of, which was a bipartisan group which put together some reforms. Now, this isn't the QUI bill. It started from the QUI Commission. It's now included a lot of other folks, but that was the impetus of all this. So that's one idea that at least I've had. The other thing, whether we do retention elections or not, is a performance evaluation system that's meaningful and it includes a majority of non-attorneys. That is something, or at least parity, a floor of 50% of non-attorneys. Because right now, as Mr. Dean said, other than the incumbent designation, people really have very, very little information about judicial candidates and judicial elections. Part of that's just natural interest. Most people have busy lives and they don't really care to look way down the ballot and spend the time trying to find out about these things. But that's only part of the problem. The other is there is no meaningful performance evaluation. And I've been disappointed. I'm an attorney, and I've been disappointed by, again, the reflex, particularly in Hennepin County, against a performance evaluation. And there's some prominent judges there and the judiciary as a whole in some cases that have really reacted very strongly against what any of us, not only in our legislative jobs, but in our other jobs if we have them, would consider to be typical. It is a reasonable expectation, whatever your job you're in, whether you're in an elected office or not, that you're going to be evaluated by somebody, a superior, a peer, a colleague, an organization, institution, for whatever it is the rest of you do. That is a reasonable expectation. And I've been disappointed in the past, with, particularly in Hennepin County, but elsewhere as well, with the reactions by some judges that somehow this is unfair and it's going to be too subjective and it's people won't get it and people can't be trusted. People who aren't lawyers somehow can't be trusted to evaluate judges, and I think that's a mistake. I think that undermines public confidence. So I'd like to see, and I have some ideas about that, which I won't take up more of the committee's time here, about how we can implement in Minnesota a meaningful performance evaluation, not just for district court judges, but for all judges and justices. I think in our daily lives we expect that we're going to be evaluated in some way in our jobs by the people who work with us and around us. And so I just wanted to throw that in there. Thank you for indulging me, Mr. Chair, on that. It's just that I have this committee meeting that I had to leave, and I'm sure there will be a robust discussion. Some people will disagree with me, some will vehemently disagree. Some will agree, some will disagree, but thanks for your time. Thanks, everyone, for coming.
Thank you, Representative Simon. Appreciate it. We're going to move into the solution phase now, if we could, and that is, we're going to start out with Greg Worsel, and that is on, coincidentally, judicial elections. We're going to talk a little bit about that.
Yes, thank you very much. My first suggestion is that if you want to have meaningful elections where the public interest is actually served, the public has to be able to get information, the public has to, and that means candidates have to be able to discuss their views on legal issues, they have to be able to raise money, and they have to be able to get a message out to the public. For many years that didn't occur, in part because of rules created by our very Minnesota Supreme Court. And I want you to understand that what their goal was to shut down the election system. And they wanted to create a system where the public had no knowledge. They actually prohibited judicial candidates from stating their views on legal issues and from raising money for a campaign. That was prohibited conduct. If a candidate did that, they could sanction him by taking away his license to practice law. Now, you have to ask yourself, why would you ever want to create a system like that? How would you ever become elected yourself? Well, you see, as long as they had the word incumbent on the ballot, they had an ace in the hole. So they actually wanted a system where the public was dumbed down, where the only information out there were two names on the ballot, where one was followed with the word incumbent. And if you want to actually have the public know what's going on, then my first suggestion to you is you have to eliminate the word incumbent. You have to create a competitive election system, and that is going to make a big difference. There's another suggestion. Almost all of our judges right now, about over 90%, have been appointed to their position. And that's happening because again and again and again, we see judges retire before the end of their term. And then the governor gets to appoint somebody to that open position. Now, I want to give you an example. In Dakota County, in 2006, there were several incumbent judges up for election. None of those judges were challenged. But you know what? There was an open position where a judge actually completed his term of office and allowed attorneys to run for that office. 13 attorneys filed for that open position. My point to you is that attorneys do want to run for these positions. Attorneys will run for these positions, but they're not going to run against the word incumbent. You've got to get rid of that. The other thing is that because of this process where the judges are continually retiring before the end of their term, we've created a system where basically, like I said, 90 to 95% of the judges are elected. My suggestion to you, a simple solution, would be to encourage open seats. And the way you would do that is that you would go after the pension system. My suggestion to you is, if a judge retires before completing his term of office, there should be some sanction on their pension. Whether you want to say they don't get any pension, whether you want to say they lose 10% of their pension, I don't care what it is. There should be some sanction. Now, again, if the judge needs to retire because of a medical reason, that's understandable. But that's not what's happening out there. That's not why we've gotten to the system where we've gotten to today. Where we are today, all these judges are retiring before the end of their term. This is part of the plan. and we need to stop that behavior. We could then create a system where approximately, if you look at the judges, there's probably 5 to 10% of judges every year are retiring and are being replaced by the governor. If we could encourage those to be open seats, we would have 5 to 10% of the judges of those positions coming up every year as open seats, competitive elections. And that would be a good method to look at. I would just mention, because the Representative Simon mentioned a judicial performance committee, I want you to understand that the committee that's currently being proposed, it's with Senate Bill 70, I'm not sure what it's labeled here in the House, is never going to work. It's not going to work because there are going to be attorneys on the committee, and they are under the thumbs of the judges. And it's not going to work because it specifically says that they can look at things that are meaningless, such as whether the judge is punctual or whether he's a good communicator, but they can't look at the judge's decisions. It says that any decision that's an appealable decision is not going to be under the purview of the committee. Well, everybody who just got through testifying here today, all of those decisions that the judges made were appealable decisions. And if you eliminate that from consideration, then any judicial performance committee is a joke. And that's the problem with it. That's why competitive elections are so important, because you'll have a candidate come out and say what's really going on and present issues to the public, and then the public can make a decision.
Mr. Wurzel, is this Senate File 17, is this the constitutional question?
70, yeah.
70?
Yes, 70.
But if I might, is that the bill that the Quay Commission and the
Correct. It's the bill to create judicial retention elections, and inside of that bill, there would also be placed on the ballot a recommendation from a judicial performance committee that the judge is either doing an excellent job or a mediocre job, or that the people shouldn't retain the judge.
If I might, this bill appears to be gaining some steam around here this session, and so it's, sometimes we call it putting lipstick on the pig, if you will, and you have to make a decision whether or not you want to do it or not. I mean, sometimes it's easier to kill something if you keep it really awful, but you have to make the calculated decision as a legislator. If you think something's actually going to move and get passed, at some point you have to just say, well, I'm going to work to try and fix it the best I can, because if this actually goes through. So I guess I'm kind of, if you could give us some feedback, if you will, as if in fact this thing is headed for approval. And of course the governor can't stop constitutional questions, and as we've seen recently in this state, things that I thought would never pass have passed. So depending on how the wording is on the ballot, if you put a question that's 72 words long, which is what the last question was, people tend to just not pay a lot of attention, I think, to what the ramifications are. So if you might give us some ideas on how we can make this better, if in fact it's actually going to move.
Well, here's my first suggestion. Let me simply say, I think judicial retention elections are a disastrous idea. Understand that we are where we are today with the abuses we have because we basically have an appointed judiciary, that we don't have competitive elections. And the idea behind the judicial election bill is that all the judges are going to become appointed by the governor, every swinging one of them. And then they want to create an 8-year term, and the only thing they're going to look at is whether the judge was, I kid you not, if you look at what it says, this Judicial Performance Committee is going to look at whether or not the judge was punctual, whether or not he's got a good disposition, but not be able to look at the decisions. To be honest with you, it's totally meaningless. Let me give you just think about this. It's possible that the governor could appoint somebody, and that person could be a racist, and make racist decisions, always ruling against blacks or Hispanics. And the public isn't going to have a chance to approve or disapprove of that judge for 8 years. And then if that judge is just a little bit smart, I mean, all he's got to do is couch everything in legalese. As long as he doesn't say, I'm ruling against you because you're black, all he's got to do is couch it in legalese, and it will then be a decision that's appealable to the Court of Appeals, and any decisions that are appealable can't be considered by the Judicial Performance Committee. Do you understand what you've created? You've created a monster. And that is why I am so emphatically against the idea of judicial retention elections, because they won't work. The people of Minnesota will be disserved. It's just a disaster waiting to happen. I hope I answered your question. To make it better, I wasn't, there are some ideas I have, but to be honest with you, I maybe have to submit those in writing, because I didn't come prepared to talk about that the other day. I shelved that in my memory somewhere else for the time. But again, on the whole, I view it as a total disaster. Another problem.
Mr. Wurzel, I mean, I'm struggling with this issue as a legislator. I mean,
yeah.
I'm not going to turn this partisan, but if everybody in the room might think of the social interest group that they most oppose, pick whichever one in your realm of what you think is important, and if that particular organization spent $10-12 million trying to get their Supreme Court judge candidate elected and win, and at what point do we end up with a judiciary that reflects who has the most money and most political power in the state of Minnesota?
Well, and I think I have an answer for that, which is I think judicial retention elections will create more partisanship in the judiciary, not less. And let me explain why. If you have an election, it's up to the people of Minnesota to decide whether or not that judge is too partisan. But if you have a judicial retention election, all those judges are appointed by the governor. So I don't know what your political persuasion is, but there are many people who would say that our current governor is a right-wing ideologue. And, in fact, that he is appointing other right-wing ideologues to our court. There was an article by Nick Coleman of the Star Tribune in December of 2007 where he talked about the fact that Pawlenty was creating what he called the Pawlenty Court. At that time, Pawlenty had appointed 3 judges to our Minnesota Supreme Court. He has now appointed 4. My suggestion to you is that soon he will maybe appoint 5 or 6. I don't know what your political persuasion is, but I do not want any governor creating a court in his image and then not have adequate protection of an election for the people to hold that in check. And this bill is going to appoint these judges for 8 years, and again, their decisions, which are appealable, are not to be considered by this committee. So the people of Minnesota will have to wait 8 years to try to have their first shot at looking at how partisan these judges are. And then their partisan decisions won't be considered. I think this is, again, very dangerous. And I'm going to tell you, I think we will end up with a far more partisan court than we have now. I think the people of Minnesota are able to choose, they can wisely choose the people in the legislature, they can wisely choose a governor. I fail to understand why we are so afraid of free and open elections in this state for our judges. Thank you.
Thank you, Mr. Wurzel, and I appreciate the opportunity. We're going to go on to the other ones as well. Obviously, the elections issue is a huge issue that's going to be before us in the body here. I would encourage, people here to contact your legislature, give them their feed on this. I am a firm believer on the other side with Representative Wurzel that opening up the elections is really the only way that we get the judicial branch back to the grassroots of the people, which is what, and I'll just take a little liberty just right now. If we go back to our founding documents, they go back to the Constitution, the initial place of the judiciary or of the judicial branch was to allow a trial by your peers. In other words, there was a jury trial that was supposed to take place where members who were your peers had an opportunity to hear the facts, and the determination was made based on those facts, and the judge simply facilitated that process. Since we've migrated from that process, we've seen the judicial branch grow, we've seen some things happen that we were never intended in our founding documents. And so now we have a migration of a judicial branch that was never intended in our founding process, that they are acting on their own. And those are some of the things that I believe, now this is just me speaking, and I believe that we're dealing with now in terms of judicial influence on our societal norms. So having said all that, that's not anybody else speaking but Citizen Dan Severson. Any other inputs? I guess we'll go on to the next Board of Judicial Standards by Dale Nathan.
Thank you very much for inviting me. My purpose today is solutions. My name is Dale Nathan. I'm going to confine myself to solutions, but I also am going to respond to Representative Holberg's comment, and I believe I'm going to be of considerable help to you with respect to the issue of retention elections, but even more important, judge elections. And in that connection, I am going to invite everyone in this room to take note of a hearing coming up next Wednesday before the Senate the Senate Local Government Committee. And that particular hearing concerns the ballot question. What is the question that is going to be presented to the people about judge elections? Here is the current question. Bear in mind that what is being proposed is to change the process for selecting judges from election by the people to appointment by the governor. Keep that in mind, and now listen to the question that is currently being proposed. Shall the Minnesota Constitution be amended from the current system to asking voters to decide whether Minnesota judges shall be retained in a retention election after a public performance evaluation by a nonpartisan panel? That's the question. What did you hear in that question about the governor having the power to select and appoint judges? The committee meeting this coming Wednesday, local government committee meeting, room 123 in the Capitol, will decide whether or not that question should be changed. Here is a proposed revised version. Shall the Minnesota Constitution be amended to provide that judges be appointed by the governor, and thereafter voters will decide if judges are retained in office in an uncontested election? This particular page lists the 11 senators who are going to decide what is going to be the ballot question. And I invite each of you to take one of these, contact particularly these senators, and let them know that you want a fair question asked of the people if this matter goes on the ballot. Having said that, I'm going to confine myself to solutions. I have here 9 proposed bills. These 9 bills are the product of years of work. They come from books, from law review articles. Most of these are common sense. The significance of what I am presenting, I hope, is that there are others who have worked on this, are handing you, the legislators, proposed bills to make common sense changes to Minnesota law. Let me again address Representative Holberg. You just mentioned what is a common comment nowadays, and that is, what if millions of dollars are thrown at, in this, actually appellate court judges? You rarely see it at the district court judge level. But as in Wisconsin, as in West Virginia, as in other states, what about special interests coming forth and buying judges? That is the basis, largely, of the appellate court drive to get judges appointed by the governor. I would like you to be aware of the North Carolina plan, because North Carolina had the same problem. They addressed it and they solved it. In North Carolina, a 2004 law in operation provides public funding for judge campaigns at no cost to taxpayers. Sounds impossible, doesn't it? But North Carolina did it. We have a proposed bill modeled after the North Carolina law, and I hope sincerely that you legislators will take a look at that bill and let's consider it for Minnesota, because what that bill does, it funds judge elections, it assures nonpartisan judge elections, it assures ethical campaigns. In short, it causes us to have the kind of elections that we're proud of. How do they finance it? Very simply. In North Carolina, as in Minnesota, lawyers pay an annual license fee. They raise the annual license fee by $50 a lawyer, and I assure you lawyers can afford another $50. And with the money that they have, they finance judge campaigns. In order for judges to get this public financing, they had to agree to run nonpartisan, they had to agree to spending limits, they had to agree to ethical campaign practices. And it's working. This is not Dale Nathan saying something works, it's North Carolina. I urge you, therefore, to take a look at the bill that we put together that would address these problems. In addition, we have put together a bill on judge and judicial officer accountability. If you are familiar with the Office of Legislative Auditor, you know that there's a state agency that works for the legislature that provides oversight of the executive branch of government. We are proposing a parallel legislative agency that will provide oversight of the judiciary, and it's based on the constitutional provision that Representative Severson referred to earlier, Article 6, Section 9, which gives the legislature the authority to provide, not only the authority, the duty to provide oversight, discipline of the judiciary. I urge you, therefore, to consider the bill that we have put together that we think is common sense, that will bring accountability to the judicial branch of government. We have put together a judge performance evaluation bill that avoids some of the pitfalls Mr. Wursel just spoke about. This performance evaluation system excludes lawyers from evaluation panels. Why? Because no lawyer in his or her right mind is going to negatively critique a judge before whom that lawyer might appear. That's common sense. You want an evaluation system that's credible. We have a legal system information center that will provide assistance to citizens in finding lawyers and in assuring that you get quality services. We have a judge selection bill, and I think Representative Severson, you're working on that bill right now, together with Senator Gerlach. I think it's a very promising bill, and we certainly look forward to working with you. Judicial ethics. It's true that judges passed a rule that enables them to get as many $150 tips as they want per day. That needs to be ended. We have proposed a bill that not only would end the $150 tips, but would impose the same code of ethics on the judicial branch of government as now applies to the legislative and executive branches. Judges have made their own code that allows them to do more than what legislators can do. Grand jury, you're going to hear about that in a little bit. We have a proposed bill to allow citizens to petition for a grand jury investigation instead of not allowing investigations if a single county official resists it. Judge campaign financing, I spoke about that. We have a bill ready to present to you for your consideration. Family matters, we have a bill that addresses several of the problems that you heard about today, that avoids, at least set standards to prevent wrongful termination of parental rights, and that sets standards for visitation by the parents of children. And last, lawyers, license, and oversight board, we are proposing a law that sets up an independent agency to provide oversight of lawyers and to license lawyers so that the judicial branch, the judges, are not dominating lawyers. Last, most important, the reforms that we are proposing will not cost any additional funds. These are self-financing, and that, of course, is something that's essential. Thank you very much.
Thank you, Mr. Nathan. I appreciate it. And those, again, there's a lot of reforms in here, and one of the important issues that need to be dealt with down in the legislature is you got to pick your battles here. And obviously, there's 9 bills here that we're talking about, and our ability to get any of that done is dependent on priorities. Funding is a big issue this year, but I think one of the things that needs to be determined is what are the top tier issues? What are the 1, 2, 3 big issues that we want to press forward this year? It becomes overwhelming when you just put everything on the plate and then nothing gets done. We need to have a focused attempt, and if you're willing to jump into that and give us your input on what are the top 2 to 3 items, those would be the issues that I think we need to address.
Judicial accountability is certainly a top issue. I'll agree with that. I would put performance evaluation, because it's a part of the same system we propose. And number 3, I would put judge elections, which is what you're working on, and that is a hot issue this year. So those would be my candidates. Some would argue that grand jury.
Right.
Understand that there are different priorities from different people.
Okay. Thank you, Mr. Nathan. I appreciate it. Next we have Nancy Eisra. On impeachment.
Now. Oh, all right. I thought it was at the end. Okay. Well, thank you, folks, and committee members, and Representative Severson. My name is Nancy Lazaryan. I have been working for over 18 years on these matters. Some of you know me as a frizzy-haired woman with a camera and the microphone that comes down here and causes a lot of noise. But all the noise that I make is based upon well-researched and backed up evidence and knowledge. I carry with me a lot of the knowledge of the cases of the people that are here in this room. And I'm hearing there is no accountability. I'm hearing separation of the branches of government. But I'm not hearing about the checks and balances. And there are certain checks and balances that we did put into our Constitution, which, by the way, our Constitution is our contract. All these people here were under contract on how we live together. And we established this government, and we established a judicial branch, and we just established a legislative branch, and we established an executive branch for us, to serve us. That's what we did. And one of these branches of government is no longer serving us appropriately. And we're here with our evidence, and we're here before our legislative branch, and we're asking our legislative branch to do what we've afforded in our Constitution, our compact, the power for you to do, which is impeachment. Impeachment is necessary because we do not have the judicial accountability steps, processes, so that there have been certain judges that have gotten so out of hand, that have gotten so egregious with what they have done, that it calls for impeachment and it calls for it to happen and it calls for it to be immediate. It has to happen this session. And when I have in front of me the complaints are our petitions. Our petitions are provided to us under the federal Constitution. And the word petition means our right to change the thing that we created. We created this government, and we are petitioning our legislative branch to change different things that are happening in our judicial branch through impeachment. So what I have in front of me here are pages and pages and pages of evidence and complaint concerning outrageous, egregious behavior of certain judges. Back in 2003, there was a case that was actually brought, bills of impeachment, bill of complaint at law and articles of impeachment against 3 judges in Benton County. Happens to be involved in my own personal life, and attached to this document was 140 pages of evidence that felonies and conspiracies being committed in Benton County concerning 3 judges. This particular complaint was served upon the judges involved. It was served upon the Judiciary Committee in 2003. I got a letter back from Steve Smith, who was the chair of the Judiciary Committee. And actually, before bringing the bill of impeachment, we did go to the Board on Judicial Standards more than once. The Board on Judicial Standards says we needed to appeal it. We did appeal it. In fact, we went to the Supreme Court, and we got a ruling from the Supreme Court that the judge, in fact, was violating the law. But here's the thing, folks, and this is what I want you to understand so clearly in your mind. The Minnesota Supreme Court cannot impeach a judge. The Minnesota Supreme Court now is in control of the Board on Judicial Standards. That's our only safety valve right now. That's the only place that citizens can go to, is what's been described as a black hole. A board that's controlled, it's in secret, and they only make recommendations to the Supreme Court. And the Supreme Court cannot impeach. They cannot remove an officer from office. That power lies here in our legislature, because this is where the people put that power. And so we went through all the processes. We went through the Supreme Court, and the Supreme Court even said, this judge is doing wrong. So you know what? We took this to the legislature. It got buried, and it got sent back to the Board on Judicial Standards, who then said, we can't do anything about this. They can't do anything if a judge does something wrong from the bench that violates someone's rights. You know why? That's your power. That's your duty to do something. So I have this complaint. I'm going to be presenting it to the committee, and I